Federal rules of evidence for criminal trials. Today we're going to talk about 3 of them in Article 4. They all relate to relevant evidence. Only evidence that is relevant in a case can be admitted into evidence. Well, what does that mean? Rule 401 states that evidence is relevant if A, it has any tendency to make a fact more or less probable than it would be without this piece of evidence, or B, the fact is of consequence in determining the action. So look at it this way. For the first part, it has any tendency to make a fact more or less probable than it would be without the evidence. Say you're on trial for murder, but you have an alibi, and you say that you have an alibi, but then you are also able to come up with some corroborating documentary proof that substantiates your alibi, like a video recording that's time-stamped of you at a certain place at a certain time. That piece of video corroborates your testimony, which would make that fact more likely, more probable, with the addition of this video time-stamped recording, which goes directly towards the consequence in determining the action of the case. So, why am I talking about this stuff now? As it relates to Donald Trump's indictment for January 6th, efforts to overturn the results of the 2020 election, I have seen several TikTok creators on the right saying, oh man, Biden, Merrick Garland, and Jack Smith sure stepped in it now, because now Donald Trump gets to prove in a court of law in front of a jury in a federal courtroom that the 2020 election was stolen. He gets to call any witnesses that he wants to. He gets to introduce any evidence that he wants to. And now he gets to prove that the 2020 election is stolen. And boy, are Joe Biden and Jack Smith going to regret ever indicting Donald Trump. Just as in 2020, when they became sudden and immediate experts on communicable diseases and COVID, and then in 2021, they became experts in immunology and viruses. And in 2022, when they all became experts in the global economy, gas prices, and inflation, now in 2023, they're experts on federal criminal jury trials and the federal rules of evidence. As with the one thing that is true about all 4 categories of their claimed expertise, they were always wrong about everything all the time. And that pattern continues here. A criminal defendant does not get to introduce whatever evidence they want. They don't get to call whatever witnesses that they want to. Witness testimony during trial is evidence. And all of the evidence that is introduced has to be relevant with that 2-part test that I just said. It's got to be of consequence in determining the action, meaning that it's got to go directly to the charges that the defendant is facing, or it has to go towards some legitimate defense that defendant might have. And a lot of that stuff's going to get worked out during pretrial motions, because now I get to prove that the 2020 election was stolen in a court of law has absolutely no relevance to this case whatsoever. He's not being charged for that. And that, first of all, there is no evidence that the 2020 election was stolen. That evidence does not exist. And so, well, I'll save this example for a minute here. It's like, does the item of evidence tend to prove the matter sought to be proved, the charges, or a legitimate defense that the defendant has? The 2020 election was stolen, and now I get to prove it in court. It has nothing to do with anything. Rule 402, the general admissibility of relevant evidence. The conclusion of this rule is the only part that matters. Irrelevant evidence is not admissible. But the flip side to that is not all relevant evidence is automatically admissible. There are limits. And, like in Article 5, there are privileges, like attorney-client privilege or doctor-patient privilege. Article 6 imposes limits on witnesses and what witnesses can testify about. Article 7 gets into requirements with respect to opinion testimony or expert opinion testimony. Article 8 is a big one, excludes hearsay that doesn't fall within certain exceptions. Article 9 deals with the authentication and identification of documents and things like that, and on and on from there. So it's like the First Amendment. It's not without limits. Now, this argument that Trump gets to introduce anything he wants to at trial brings us right up against Rule 403, excluding relevant evidence for prejudice, confusion, waste of time, or other reasons. And this is arguable because, as I said, the election was stolen is not relevant to this case. But even assuming that assume for a second, for the sake of argument, that it is relevant. The court may exclude relevant evidence if its probative value is substantially outweighed by the danger of one or more of the following: unfair prejudice, confusing the issues, misleading the jury. You think Trump and his attorneys are going to try to mislead the jury? Undue delay, wasting time, or needlessly presenting cumulative evidence. It's a balancing test. The probative value of a piece of evidence versus its prejudicial effect. Well, first of all, the probative value of the 2020 election was stolen, or say, what's he going to do? Is he going to call Mike Lindell as his expert witness in front of a jury? The judge is never going to let anything like that happen, period. As with the Mar-a-Lago documents case, which is a lock, I think that's the strongest of all of these cases that's about to be indicted, just because of the paper trail and the security camera footage and all of that stuff. Like an example of relevant evidence would be, in that case, in Mar-a-Lago documents case, would be the multiple times that Donald Trump said on live television or in interviews with people like Sean Hannity, I had every right to take all of these documents with me. That is an admission that he took the documents. An admission is relevant and is of consequence in determining the action because it goes directly towards what he's charged with. So that's coming in. In the January 6th case, there is so much evidence of Donald Trump and his cohorts running 5 different conspiracies out of the Oval Office. The court may prevent him from even introducing the defenses of it was my free speech rights to say that the election was stolen, because that's not a relevant argument to what's charged. He's not being charged with what he said. Second, his second defense of I was relying on the advice of my attorneys. Well, even if the judge lets him make that argument, Jack Smith has mountains of evidence that he relied on 2 or 3 crackpots while completely ignoring every attorney at the DOJ, every attorney in the White House counsel's office, and picking and choosing and just believing what he wanted to, which brings up a willful blindness argument. So that defense is going to get shot to hell, even if the judge does let him make it. So that's a little primer on what relevance means. And so it's like anytime it comes at you from the right with that bullshit, he gets to prove the election was stolen. Now you just say, no, he doesn't. It's not relevant to the charges, and none of that evidence is relevant. None of that evidence exists. And even if it did, it's not going to be admitted in court. Have a good day.